This is it. Our last panel is a great panel. Insider Trading 360, Enforcement Trends, Key Cases and Prosecutions, and Crypto. Let me start by introducing Samantha Choe. Samantha is Senior Counsel for Government Investigations and Special Matters at Uber, where she handles government-related inquiries and investigations, and she previously served as an attorney in the SEC's Division of Enforcement. Welcome, Samantha. From the SEC, today we have Assistant Regional Director in the SEC's Division of Enforcement, Rahul Kolhatkar. He's in San Francisco, where he served for over 8 years. Thanks for joining us, Rahul. Our moderator is Amy Jane Longo. She's a partner at Ropes & Gray in Los Angeles, a member of the firm's litigation and enforcement practice group, specializing in enforcement and securities litigation. And previously, Amy was regional trial counsel for the SEC's LA regional office, where she oversaw all litigation brought by that office. Welcome, Amy.
Thank you.
Very pleased to welcome John Sikora, a partner at Latham in the litigation and trial department. John regularly represents companies and their officers and directors in SEC and FINRA and enforcement investigations and examinations. And prior to joining Latham, John spent 16 years at the SEC, where he was an assistant director in the Chicago regional office and in the asset management unit of the enforcement division. John, welcome. Finally, pleased to welcome Dave Willingham, and I should start with an apology. Does that look like the Brad Morosky picture from last time? It might look a little bit like it, and I wish there was somebody else I could blame, but there isn't, so I did it.
Close enough.
Apologies. David Willingham, a partner at King & Spalding in the LA office. He focuses on white-collar criminal defense and complex litigation matters and has handled numerous parallel investigations with the SEC. David previously served in the U.S. Attorney's Office in the Central District of California, where he was deputy chief of that office's major fraud section. Welcome, David. Amy?
Thank you, Bruce. Thanks, our panelists, and thanks everyone in the audience for sticking around for the last panel of the day here and remotely. So we appreciate everyone's attention. I think there have been a lot of really interesting developments in insider trading in the past year, so we do have a lot to cover, but we promise not to keep everyone a minute over because I know that the bar opens right after our panel. So with that, Rahul, would you start us out by just talking about some of the Commission's priorities in enforcement in the area of insider trading, and also what are some of the issues that you're keeping an eye on in terms of insider trading issues making their way through the courts?
Sure. So I'll start by saying something you might have heard before, which is that I'm appearing in my official capacity, but the views I express today are my own and not those of the Commission, the Commissioners, or the Commission staff. I think to answer, I guess, your first question, the priorities for the division really are generating and bringing impactful insider trading cases, not surprising. And I think a focus at the division continues to be on using data analytics to sort of drive our investigation and enforcement efforts. And just a couple of examples of that, in July of last year, on a single day, the Commission announced 3 separate cases involving 9 individuals in 3 schemes. They included tippers who were a chief information security officer, an investment banker, and a former FBI trainee. All 3 also included parallel charges brought by SDNY, and all those cases were brought out of the Commission's Market Abuse Unit Analysis and Detection Center, which generates case leads based on data analytics. So it really shows the impact that sort of data analysis can have. And that's going to change going forward as the data that's available changes. So in December of 2022, the Commission also filed charges against the employee of a major asset management firm and another individual in a front-running scheme, which is a type of insider trading that generated over $47 million in proceeds. So the employee of this major asset manager essentially learned about his firm's upcoming large trades, and since it was a major firm, the trades themselves would be market moving. He tipped his friend who traded in advance of these positions and just benefited from the price improvement from the asset manager's trades. The press release in that case, I'll just noted that the commission used information gained from the consolidated audit trail to help generate those cases. So I think that's just going to be a continued area of focus, is how we identify these cases, because they are insider trading. Although I've just cited a number of examples, it's very difficult to detect from just profitable trading generally. I think in terms of cases working their way through the courts that I have an eye on, I think sort of unlike in years past in sort of the, like the Newman era, there aren't sort of ground beneath our feet kind of questions working their way through the courts. But there are important cases. Jason Lee mentioned earlier the Panawat case, which is working its way through the courts. The court there denied the defendant's motion to dismiss, and for those who may not remember the case, essentially it was a case involving an insider at Medivation who learned information through his employment at Medivation, traded in the security of another issuer, but the commission alleged that he traded because he owed it based on, in part, on the policies and procedures at Medivation. And so the defendant moved to dismiss because he argued that he didn't have a duty fundamentally. The court denied that motion, and the case is proceeding through litigation and is, I think, currently set for trial in March of next year. So I think that's one to keep an eye on, and the so-called shadow trading space is one that will continue to get attention.
Now, I think something that a lot of people wonder, and maybe you can shed a little light for us, when enforcement folks think about what cases are good candidates to bring in action, and recognizing that this is an area where a lot of the cases are based on circumstantial evidence, how do you think about what makes a good candidate to bring a case, factoring things in like staff resources or programmatic importance of the issues? Can you shed any light for folks on kind of what goes into that assessment?
Sure. Well, I think fundamentally, right, insider trading cases involve some breach of some trust. And so I think it's important for the commission to highlight roles that are likely to include positions of trust that if people don't abide by their duties can lead to some deleterious effects. And so I can think of a couple, recent examples where the breach sounds egregious, and so the commission wants to be in that space. There was a recent case involving insider trading in Kodak Securities, and it was by an individual who, by virtue of his contract at a medical supply chain company, obtained information about Kodak's likely government contract to help with COVID-19 medical supply response. And, I think using information about COVID-19 medical supply response to trade personally it seemed egregious. And so I think that's a place where the commission wants to be. I think of another example is recently there was the case against the chief information officer at the company that was formerly known as Mylan. That individual was alleged to have tipped on basically every kind of insider information that you might get at Mylan. So he tipped on FDA approval announcements that hadn't been made yet, corporate financial results, and impending mergers. I mean, it's really a wide breadth of potential MNPI there. And so when there's access to that kind of information, again, the commission wants to note that corporate insiders have important duties, particularly at the executive level, such as in the Mylan case.
And I think that's a good segue, mentioning sort of the role of executives, particularly in insider trading. I know this has been a year where we saw rule amendments relating to 10b5-1 plans, and we heard earlier today that that's a current priority of the Enforcement Division for Enforcement Matters. Samantha, can you talk a little bit about the import of those changes to the rules, and also, as an in-house lawyer, sort of what are some of the important things you think about in terms of implementing those amendments?
Sure. As I think everyone in this room knows, that the Commission adopted in December of last year amendments to Rule 10b5-1 in response to concerns that these plans might be being abused by certain insiders. The SEC also cited academic studies showing that corporate insiders trading under those plans were consistently outperforming trading not conducted under the plan. So what are the new requirements? I'll note 5. First, the rule now requires cooling off periods where it did not before. For directors and officers, that cooling off period is at least 90 days. For all other employees, the cooling off period is 30 days. Second, the rule now requires directors and officers to include a representation in their plan certifying that they're not aware of MMPI and that they're adopting the plan in good faith. Third, it extends the good faith requirement for the affirmative defense to apply beyond requiring good faith at adoption of the plan. So now it requires all insiders to act in good faith throughout the duration of the plan. Fourth, the rule now places limitations on use of multiple overlapping plans or single trade plans. And finally, there are now new disclosure requirements for issuers about insider trading policies, as well as disclosure of 10b5-1 plans of directors and officers, and policies around timing of option awards. In terms of implementation, in many respects, the amended rule does not depart from the best practices that were in place, even if they were not, strictly required by the rule prior to the amendment. For example, the cooling off periods were fairly standard, as well as certifications regarding good faith and non-possession of MMPI. As with regards to the disclosure requirements, those are what they are, and it's a matter of implementation rather than being controversial.
Interesting. And I know this is an area where we've seen just a handful of enforcement actions so far. I'm curious what your take is on those. I think we had the Cheetah Mobile settlement, which I'll note, this was an insider trading case, a settlement involving trading around a 10b5-1 plan. They included an undertaking to notify the SEC by email when the executive was going to adopt or modify a 10b5-1 plan, which seems to me like potentially a big deterrent from implementing future 10b5-1 plans. But also the Pizer on-track case, currently litigating another case involving allegations of adopting a plan at the time of possession of MMPI. Do you think we're at the beginning of a wave of these kind of cases here, or how do you think the new rule will impact those?
Yeah, as Rahul mentioned earlier, it's evident from these two cases that the government is paying close attention and paying close scrutiny to trading under 10b5-1 plans. So I suspect that these two cases are sort of the start of a wave of cases that are coming forth. And so, I think the Pizer case attracted a lot of attention because it's the first of its kind, a criminal case involving the use of a 10b5-1 plan. And, that the SEC and the DOJ paid close attention, as it appears, on the fact that the Pizer, the defendant in that case, had avoided or sort of ignored the advice of two broker-dealers in adopting a cooling off period before commencing trading. And so, if the government, based on this data analysis, sees that, the individuals likely traded based on MMPI and not in good faith and abusing 10b5-1 plans, it's clear from these cases they're not get out of jail free cards.
Anyone else thoughts on sort of how the amended rule will impact the ability to use the affirmative defense? Dave is smiling because he's involved in the Pizer case and won't talk about it.
Yeah, so I'm lead counsel for Taryn Pizer, and what I would say is not anything related to his case, but at first blush, you always have to dig underneath what the charging documents look like in order to really get to the bottom of a case, and so that's can't really say much more than that on at least that matter.
Well, let's switch gears a little bit and talk about some developments in the criminal space. I know December of last year brought us the decision in Blansack 2, a case involving allegations of trading where the information was the property interest alleged of the CMS information, and we saw that Second Circuit opinion come out. Dave, tell us a little bit about that decision and whether you think it's going to really involve a revisiting of a lot of the fraud cases involving intangible property interests. I think if you read the dissent, you have the sense that like the walls may be falling in here now, but tell us what you think, especially as a former prosecutor.
Yeah, so if you know or have followed Blazak 2, it was on the heels of the Blazak 1 decision, which was a remand after the government confessed error in the wake of Kelly, which was another case that has basically limited the government's view of what is property and what can be charged as something of value in terms of fraud. That can be, it applied Kelly and basically held that the government information, insider information with regard to knowledge of what is going to be approved or any business matter at CMS, which was the subject entity, is not property that can be subject to, well, we'll get to the insider trading counts in a minute, but at least to government theft or theft of property under 641 or even the fraud prong theory that they had charged it under. It really does limit the scope of actionable information or actionable material non-public information that the government can go after, at least in the context of public entities. Really taking some strong languages. If they're not in business of using that information or selling that information, then it's not something that can be actioned upon by the government. Interesting to note, the government did charge the case as insider trading. Charged under Title 15 and described, the court went out of its way several times during the opinion to describe that as the core of the offense that was charged against these defendants. And they were all acquitted by the jury. There wasn't really an allegation of lying, it was a tipper situation. And the jury just out and out rejected that while convicting on other counts. So really thinking these cases can be hard to prove if there's no lie. They are circumstantial half the time. They can be hard to prove and really not necessarily resonating that well with the jury. I certainly hope so in my practice. But in the end, they are not the most simple cases for the government to go after. And I think that the jury really told them that when they were pursuing this case. And the court really underscored that during the course of them. At least it was a concurring majority opinion. What I also thought, not necessarily just the dissent, which was like, well, what's happening here? You also saw a follow on that in the First Circuit case in the Varsity Blues matter, which is, I had someone in that case, and I wish we had had the wherewithal, or at least the willpower to try that case, because the government in that case, like in others, is taking a square peg and round hole theory, really trying to shove property and fraud theories down people's throats when it has leverage factually. And I think in the criminal context, it does that in many aspects. And I think, again, the jury rejected that insider trading theory in Blazak, and I think you saw the court reject it in the Varsity Blues theory in a different context. Finally, the concurrence I thought was really interesting by Judge Walker in the Blazak 2 opinion, which was basically said, we are at a place under the law, under Blazak 1, where insider trading under the criminal statute does not require proof of a personal benefit to the tipper, whereas if you were proceeding under the SEC rules or 10b-5 or any of those things in which you were going to charge it, you must actually prove that personal benefit. And really spent a long time in his concurrence saying, this is something that makes no sense to me and needs to be fixed by the courts one way or another.
Yeah. So do you think this decision will have a big impact on the kinds of cases that are charged going forward or how they're charged?
I think yes. I think the government is starting to realize that when it really does get aggressive on its legal theories, God knows there are plenty of legal theories when I was a prosecutor that you can use in other means in order to pursue a case, that you're going to run into some problems with the court. If you are going to aggressively charge some kind of property theory, be it in insider trading in terms of the knowledge or any other fraud context, they should think twice, especially in the criminal arena. And I think you're starting to see at least some effect in those theories, with defense counsel being able to push back quite a bit.
And I think it's not the only area we're going to talk about where the SEC and the DOJ have pursued different kinds of charges relating to insider trading, which I think, the fact that there are different kinds of charges always raises the question and lets folks look at, well, what are the differences in what has to be proved here, and why might one be charged one way and one be charged another way?
Right. And I think when you see two agencies approach the same problem with a different angle, then you see that maybe there is something that should be reconsidered with regard to the angle that you're taking, depending on which one's in the right. And so I think you can see that periodically. And the government getting slammed, I think, in such a high-profile case in the Varsity Blues investigation, in addition to Kelly, in addition to Blazak, I think is really hopefully going to give at least the defense bar some more footing to really take on the challenge of, do you really have this right, or are you just making a leverage play?
So maybe this is an issue to keep an eye on, not just in the context of this case, which, as I understand it, may continue in other, but now that it's come back down, but in the context of some of the other kinds of cases that the government charges. Let's turn to another recent matter brought by the SEC, the Wigovsky case, which is a partially settled but mostly litigating action. John, do you want to talk to us about this case and what was interesting about it? I know we heard a little bit about it on the SPAC panel, but let's dive into the insider trading elements of it and some of the interesting things about the charges there.
Yeah, this was a case that was charged. I would say that one of the things that was striking when you read the messaging on this case, right, is that it was a bit of a threefer for the SEC, right? They could say, the usual sexy insider trading case, and they could say SPACs, and they could say off-channel communications, all in one case. Mm-hmm. And that was a lot.
So when you say messaging, you mean that in more than one way?
I think the agency has done a tremendous job of staying on message, right? And this case was a great example of that. So, what was sort of the underlying, sexy insider trading facts? So, in this case, you had Wigovsky was a trader at an asset management firm, and he was placing trades with an outside broker-dealer that would trade on behalf of his manager. Wigovsky and the trader and the broker-dealer were good friends, very good friends, as it turns out. They were thick as thieves, basically. They were going on vacations together. Of course, they didn't go any place modestly priced. It was St. Bart's, it was Nantucket, couldn't fly commercial, they flew private. And the way the case was alleged by the SEC, you had Wigovsky from the asset manager feeding tips to the broker-dealer friend of his, and the tips were all about upcoming SPACs. So Wigovsky was being notified that his company was going to be considering a SPAC, and that SPAC is a PIPE investment. PIPE investment was going to be part of a de-SPAC transaction. So it was going to end up, those instances oftentimes end up in announced mergers and move the price quite a bit. So you had Wigovsky feeding these tips to his friend Matthias at the broker-dealer. The broker-dealer is paying for these trips, is paying for Wigovsky to go to St. Bart's with his family. He's paying for him to go to Nantucket with his family. And altogether, Matthias ends up profiting about a little more than $3 million off of 7 SPAC deals that he was tipped to by his friend. Where the SEC was able to bring in the theme of off-channel communications was that the two of them, they were in regular communication using Bloomberg chat. So if you do work with for securities industry firms, that's a very common way for people that are in the trading part of the business to communicate with each other, even across firms. They were communicating all the time. That was sort of the regular business, but the funny business, when they were going to talk about that they did through Telegram, and they were using the end-to-end encryption method, which was it was basically disappearing ink, right? There was no trace of the messaging that was left behind. It was also not subject to any monitoring by the asset manager where Wigovsky worked or the broker-dealer where Matthias worked. So they thought they were getting away with something, and as it turns out, they really thought they were getting away with something. They found out about an SEC investigation that was focused on front-running by Wigovsky, and they agreed not, to kind of lay low and not trade for a while while that was going on. And it turned out this all came to light, and the SEC brought their case. Wigovsky was already being charged in a front-running case. He's sort of he's got a few different issues in his life. He's got that, and then he also settled the SEC case. But the broker-dealer representative Matthias, he's fighting the case. I think if kind of thinking through what the off-channel piece of this is and what it might mean, I would say there's a little bit of "I told you so" in the messaging around this, which is the commission saying the reason why these off-channel communication cases matter is because if you have representatives communicating outside of platforms that are being monitored and retained by the firm, they're going to miss things, right? And so you're going to have that as a gap. It's also going to be a gap in when they come in for exams. It's going to be a gap when they investigate. It also just so happens that when you think about the litigated piece of this, we talked about circumstantial evidence. That's, the SEC and DOJ, they build insider trading cases on circumstantial evidence for the most part. The use of Telegram in that manner is going to be a nice addition to a circumstantial evidence case, right? You're going to be able to say, not only do you have the timing of the trades and the timing of the communications, on top of that, they were using disappearing ink. Isn't it obvious what's happening here? Most likely they move for some kind of adverse inference, right, based on that. They also could argue spoliation, right, which is, hey, they destroyed the evidence, and so we get the adverse inference based on that. So, they've got they have the wind at their back with the off-channel aspect of the case, and we'll see how it comes out.
Yeah, I think when you think of like a classic example of why off-channel communications are important, the example that comes to mind so frequently is, right, the idea that people would be trying to hide nefarious conduct and insider trading just kind of leaps off the page as one that would be a candidate, for that type of thing. So I wonder if we're not going to see a lot more of that kind of allegation really spelling it out in the complaint, that here's why it matters, here's where you see it, and, details around the kind of messaging that was at issue. What do folks think? Yeah,
I expect that will be a piece of a lot of cases moving forward as they find things through. The sweep is so broad in off-channel communications that I suspect there's more where this came from, and we'll see. As a kid, maybe Rahul has some inside information he can share with us. I don't know. I don't think it is anything of financial value. So,
I guess my thought is, going back, the commission's always includes, where appropriate, an allegation of communications that are made in a way that evidence some sort of scienter, right? And so whether it's someone, eating a Post-it note at a train station or deciding to use Telegram, I think the commission's probably trying to make a similar point. And so the off-channel piece, I think, here provides a contrast to, what they were supposed to do in their day-to-day business. I don't know that I would read too much necessarily into the contrast otherwise writ large.
I think there's a difference, though, in the off-channel communications. I have a couple of cases where the commission's come down very hard on texting, where it's normal people texting who might have friends and relationships versus, and I understand it, it's off-channel, it's hard to keep, and I know that there are some compliance issues that go to that, but they're treating that the same as God knows, your heart melts when you see the communication on Bloomberg that says, let's take this to Telegram. Right? And I'm like, oh, Jesus. And that happens, and you find it, and then you're like, oh, God, what am I going to do with that? Because there's nothing to do with that for all the reasons that you just said. And I think the commission, in my view, is treating those two the same. Very often in terms of its compliance, I see the compliance person in-house shaking her head, yes. But I'm dealing with that right now for two different companies where the commission is really coming down on texting. That were safe, that were produced, that were doing all of those things versus the Telegram incident. And I'm not saying there isn't an interest there, I'm just saying that maybe there's a balance or a scale that could be in place. I know that's not our panel, but that's just,
Well, I thought one of the interesting contrasts in the complaint was the depiction of the means of communications they used that were approved and preserved, right, which were like Bloomberg chats and work email, which I don't know why, if you're going to do insider trading kind of conduct, you're texting on something that is being preserved or an email that's in the system, but with the Telegram, app and kind of the differences there, which I think, it was noteworthy. I think another interesting thing about that matter is the discussion of information barrier policies and implications there. One of the issues, one of the items of information alleged to have been part of the insider trading was the fact of a security being placed on a restricted list, something I know a lot of folks deal with in this room in terms of counseling folks how to manage those kind of policies and programs. And I'm curious what folks think the implications could be for managing those kind of policies from a case like this that really brings those front and center.
Yeah, I think one thing is it points up how difficult it can be to get confidence that if you're using information barriers, that they're actually working, right? It is, the way the commission looks at information barriers, they don't give a lot of guidance on what any one company should do in setting up information barriers so that the piece of the side of the house that's got the MMPI is not in communication with the side of the house that's making investment decisions, right? That's the basic idea. How do you separate them? And the commission's guidance is you do that in a tailored way, right, to your business. And that doesn't really tell you a lot, right? How do you do it? But the other thing they say is, and you sure as heck, the whole point of that affirmative defense, and the only way you're going to get there is if you as a firm are doing everything you can to vigilantly police the policy, right? I mean, here you had, in Wagowski, I'm not sure what the firm could have done about that, right? I mean, they were putting these when the pipe solicitation came in, they were putting these SPAC companies on the restricted list promptly. Wagowski was on the MMPI side of the house, right? And he simply, he circumvented the program. But you also have to, the thing is, you have to think, okay, people are going to be looking for ways to circumvent information barriers. So how are we going to police that? And there's when you look at it, we a lot of times when we're advising clients on this is tread carefully because it can sometimes be a bit of a no-win to try to set up information barriers because you may end up with some false confidence that they're working. You may separate physically, the people on the two sides of the house very carefully, separate them by systems, all that kind of stuff. All that can be working and train out the wazoo, but unless you're really monitoring, sort of everything, the communications, trades, everything, putting it all together, you're not going to, you're going to be in a position where if something like this happens, right, you're going to have to prove the negative. This didn't, the information barriers worked. This was not a misuse of MMPI, and that can be very challenging.
Yeah, I mean, I think you can hope to show the reasonableness of the process, right? But to expect that you can get 100% prevention, you take facts like these, and it's hard to know what could have been done, if you have someone determined to kind of circumvent.
Right. Well, and we may see that, the commission may look into what Dave was saying, right? Where through the official communication channel, right, if you were monitoring it, you could have seen that they were also using an off channel, and then that suggests that you should be monitoring better because, you missed that, right? So you could see arguments like that. Hopefully, Rahul, you're not going to turn that against us. Don't weaponize that. But
just writing it down.
Yeah, there we go. But I think there could be more of that to come.
Rahul, anything you can share with us in terms of how staff looks at issues like information barrier policies or, kind of ways to make most use of them in an investigation?
I think the staff is always concerned with looking at what the specific policy was and the specific access points to the MNPI. I think that's the most important thing. I guess to the point of whether you advise a client to set something up or not, the alternative seems worse. But I think it's really specific to are the policies set up in a way that again, you're going to have someone who likely has criminal exposure, who's not going to care and is going to find a way around it. But does it provide adequate deterrence, and is it not just kind of a information free-for-all?
Sure. Samantha, anything you want to share in terms of, from an in-house perspective, looking at this kind of issue and thinking about, the reasonableness of your procedures and policies versus, under 100% prevention, if that's like the hope?
I don't think you can hope for 100% prevention if somebody's determined to evade the rule. I think it's just best to design the policy the best you can, and also provide training to your employees as best as you can, and make the policy, the awareness of the policy more broad among the employee base, so that you exert the best efforts to show good faith. If there were some violations of that policy that comes discovered.
Well, great. Let's switch gears a little bit and talk about another decision from this year. It was a big year in appellate decisions here. We had the Clark case out of the Fourth Circuit. That was a matter where the SEC had appealed the grant of a judgment as a matter of law to a defendant in an insider trading case. And the Fourth Circuit overturned that and stood back. So, Rahul, do you want to share some insights about that case, and how does it affect, if it does, the staff's willingness to kind of proceed with cases that are largely circumstantial evidence based? I thought the decision contains a lot of discussion of kind of what evidence there was, and obviously they took a different view of it than the district judge.
Sure. So, I mean, just at a high level, the facts of Clark were that the commission alleged that Clark traded stock after he received information about a potential merger from his brother-in-law, who was the issuer's corporate controller. At trial, Clark moved for judgment as a matter of law at the end of the commission's case because he argued the commission failed to present evidence that the controller knew about the merger at the time Clark started trading. To answer your second question first, I don't think it necessarily impacts how the commission's going to approach these because, I mean, one, judgment as a matter of law after one side presents their case tends to be rare. We hope it doesn't happen enough to create more appellate precedent on it. And secondly, I think the Fourth Circuit's opinions was pretty clear in overruling the district court's order. Clark just cited to Dirks for the proposition that the commission can rely on circumstantial evidence when proving up its case. And the Fourth Circuit kind of went through the evidence at trial pretty meticulously. I mean, these are just some examples, but the controller and the chief accounting officer who did know the MNPI were very close friends. They vacationed together and in fact owned a vacation house together. They played poker weekly. At the same time as Clark started trading, his brother-in-law started reaching out to recruiters because he was looking for another position, presumably because he knew there was going to be a change in control at his company. The Clark himself took really aggressive steps to conduct his trading, including liquidating a bunch of other accounts, taking a high-interest loan. I mean, all those are circumstantial facts, yes, but circumstantial facts showing that he's acting with some degree of confidence in his trading. Clark also lied and admitted lying to the FBI in the course of the trial. So an important part, I think, of the Fourth Circuit's ruling was that it's not necessarily for the court for the district court to rule on credibility at the Rule 50 stage. That's really the province of the jury. And so, again, insider trading cases are always extremely fact intensive. And circumstantial evidence is an important part of building that kind of complete factual picture. And I think that the decision reflects that.
Yeah. Dave or John, how does it affect your defense of a case where, it's a case that falls more on the circumstantial range than, something with perhaps more, concrete evidence to deal with?
I've tried a bunch of cases, and I think it's always about the mosaic that you're trying to build. I mean, both if you're the prosecutor or the commission trial counsel, just saw John Barry earlier, or the defense lawyer, where you're trying to build this story in the mosaic. And the more circumstantial the case is in terms of where the commission is putting its case together or where the DOJ is putting its case together, the more it gives me the opportunity to pull out that Jenga block of where it is that they are really focused and how I can really take one or two facts and flip them around and really create my own mosaic and really undermine the story, the theory of the case. If it's more direct, if you've got really bad circumstantial evidence, right? Let's take this to Telegram statement, then you've got another thing coming. And I know when you're in the middle of the analysis, I always am just trying to put it all out there in front of me so I can see it and then make my own determination of whether or not I think I can win it, right? I love it when we do, but then oftentimes if you believe it, you tell the government you're going to win. Sometimes you tell them why. They tend to make different decisions about their case, usually.
Yeah, I mean, I think one of the challenges of a very circumstantial case, one person's strong circumstantial case may be another's, particularly weak or, absence of conduct constituting a violation. I don't know, John, how do you factor that in when you're defending an insider trading case?
Yeah, no, I think that is true. The circumstantial evidence is in the eyes of the beholder, right, as far as what they see. The staff a lot of times will see a little bit maybe what they want to see, right, which is I want to see a case, and they might round up a little bit, and that's what creates the opening, right, which is, gap filler here or there, Telegram was involved, or, see on Signal, and we got them. Well, is that really the straw that breaks the camel's back, or is that an opening, to Dave's point, which is they're missing a complete case. And I think that, it's important to come back to them and, to the staff and when you have cases where your client truly does have a defense and you do have to tell a story, right? You can't just say, my guys took 5 and, you can't prove it. That's not going to be very compelling, right? If you're going to talk to the staff about, whether a case should be brought. But really, tell a story that is what you believe to be truer to the actual facts of the case and the context.
I had a meeting with the director of enforcement, who was Terezzi at the time, and the New York regional office, where they were making the circumstantial reference and really putting pieces of something together that really didn't fit. And we tried to show them in the Wells process what they were missing, and they charged it as an AP, and then we won. I mean, at the end of the day, we got half the case dismissed, and their fraud cases they just lost. And I think it's because sometimes when they rely or think too much, they can cobble a sentence here or something here and put it all together circumstantially. They're missing the bigger picture. Even though if you just look at those 3 or 4 or 5, 6 things, they can put something together and they can plead something, but can they prove it when it comes to really putting it forward in court?
Yeah, and now they have to go to court, right? I mean, they're not going to use the administrative forum for these kinds of cases anymore, at least for the time being.
I guess just one thing to add on that, though. I mean, I think juries recognize the weight of circumstantial evidence. I mean, I think recently in this district, the U.S. Attorney's Office for the Northern District tried a case against a former IT exec at Palo Alto Networks, and sure, there was some direct evidence. You know, I think from the folks in the room, like some of the summary witnesses and the circumstantial evidence was some of the most damaging to not only the defendants, but I think the defendant's family kind of reacted viscerally to it, given the strength of the evidence. So I think juries, we talk a lot about circumstantial and direct evidence. Juries have the ability to put together that big picture mosaic, but you're right. It depends on does the story you're telling meld with all the facts, and is it not just a certain selection of the facts?
Yes. You'll be surprised here. I don't disagree with you. I actually think you're right that it can be very powerful if you have the right mix of the mosaic of that circumstantial evidence. I think where the commission tends to get itself in trouble is when it's just ignoring what's over here off to the left because it doesn't fit in with the narrative, and that happens more often than one would think.
Well, I think it's also, not to bring everything back to e-coms, but it highlights that it's helpful if you have the record of what your side of the story, is based on. So if you have the emails, if you have the pieces of evidence that make out your defense, obviously that makes your job a lot easier as defense counsel. So there's that benefit on the preservation side as well. Well, for our last topic, we want to make sure to talk about crypto because it was in the description of our program title. So, and crypto. I know the crypto panel talked a little bit about some of the insider trading cases that have been brought in this area, but we thought we'd just focus a little bit on Wahi. I think we're sharing a collective sigh of disappointment that we may not see an outcome on the 81-page motion to dismiss in the SEC's case there, just because it would have been so interesting, especially with all the amicus briefing, although I note that it's just an extension of the schedule for settlement discussions, so you never know what may happen there. But Dave, what do you make of kind of that and the OpenSea DOJ matter, and sort of where do you think this space is going?
I thought the distinction between the DOJ filing in the same for the same defendants and what the SEC decided to plead was telling. The DOJ had them dead to rights. They entered guilty pleas and could have charged them with whatever they wanted to, and specifically refrained from charging them with securities fraud. And I think you see the commission take the position in the wake of the resolution with Main Justice and decide to try to take on the battle of this is a security, these are securities, I should say. I think it was really interesting when you took a look at the motions to dismiss. I'm sure they did not expect the 12b6 filing on, these people, they don't have a lot of money and they already pled guilty. Why are they dealing with the 12b6? Well, because probably they felt pretty strongly that it wasn't the right thing to do and they thought that they could win that battle. And then you saw a huge industry movement to really take on whether or not these tokens were securities and able to be regulated by the SEC. And I think, to me, it really is an interesting dichotomy, which is, again, regulation by enforcement. You see a real square peg round hole theory, very difficult for them to show in this circumstance, and probably didn't expect that battle. Got that battle, and we'll see where it resolves. It looks like it's resolved, and we'll see where it goes. But to me, I found it pretty fascinating. in terms of going through the docket, and especially going through the amici, which is, you've got real law firms, real industry players taking on and saying this was not the right thing to do, and you've even got another agency saying maybe we shouldn't be poking our heads into that arena. So.
Yeah, and I mean, I think a fight up ahead is over whether the staff, looks at Wahi and says it's precedential, right? We sometimes hear that, right? In the case of settled cases that aren't truly litigated in a way that they ever get to the merits, right? It's not precedential in the sense that, in the way a court would look at it, right? But sometimes we hear that in our discussions with the staff. So we'll see if that's a fight that, we end up facing down the road.
Let's give Rahul the last word on our panel. Rahul, do you think we should expect to see insider trading in crypto cases as a significant part of the docket going forward?
I don't know. I mean, the commission brings a ton of insider trading cases every year, so I don't know whether to describe it as significant. I think Dave was chatting earlier and mentioned Gerbier's speech, focusing on the economic reality of certain transactions.
I pulled back from that.
I guess the one thing I'd say is, I don't know that it's a great surprise to the commission where, something in the crypto space draws a great deal of resources and briefing from Amici, right? Like, maybe, I don't know how surprising that is necessarily, but again, the commission, whether or not justice decides to charge securities fraud, Title 18, wire fraud, whatever else they bear to do, the commission makes its own independent charging decisions, and I think it's one thing we try to keep in mind is it's important for us to do that and reach our own independent judgment.
Very good. And we're right on
time. Thank you. All right, so just real quick, thank you to everybody for sticking around. I really enjoyed it. I hope you guys did too.